Hello and welcome to today's IVCA webinar, Decoding the Digital Personal Data Protection Act, Implications for Startups, Investors, and the Alternate Capital Ecosystem. We are joined by a fantastic panel today. Please welcome Abhinav Jain, CFO and General Partner at Gaja Capital, Ashish Fafadia, Managing Partner at Blume Ventures, Ashok Hariharan, Founder and CEO of IDfy, Shreya Suri, partner at CMS INDUSLAW. And to steer this important conversation, we have Avimukt, founding and senior partner at CMS INDUSLAW. Who will be moderating the session. Thank you all for being here, and we are looking forward to an insightful discussion. Over to you, Avimukt.
Thank you very much, Paramita, and thank you everyone for joining us today. So the topic of the discussion is on the data privacy law, India's answer to the EU GDPR, the DPDP Act. So what we'll try to do in this session is decode its implications for startups, for investors, and the ecosystem at large. Now, sometimes people feel, will this law ever be implemented? It is now coming to 2 years. In August 2023, Parliament enacted the DPDPA, but the rules, famous or infamous, are still in the works, which may not be a bad thing because it is always good to deliberate over such an important piece of legislation, which can have huge compliance burdens, a lot of consequences in terms of disputes and controversies. So it is good in a way that the government is taking its time, but it is almost inevitable that this law will come in some shape or form. So we will go through this law, and we have a good, healthy panel to discuss different aspects of it. So what I'll do is I'll start first with the expert, Shreya Suri, partner in this law. So Shreya, now from a startup perspective, the DPDPA defines startups as data fiduciaries. It entrusts them with the responsibility of collecting, storing, processing, and protecting the personal data. Now, we all know that startups are rocket ships, right? The purpose of a startup, initially at least, is to move fast and break things, in the words of Mark Zuckerberg. How do you think they can approach the challenges of this law and also do everything else which the investors expect them to do to actually grow as a business?
Thanks, Avimukt. Insightful and relevant question for the panel and the audience. So with respect to startups, yes, first and foremost, they have to be mindful that, there are certain exemptions laid down under the Act for them, but A, it does not apply to every startup, and B, the exemptions are not entirely from the scope of the applicability of the Act. So as far as a startup is concerned, I mean, in our line of work, we do hear that we have exemptions, we can deal with it later. It's not that much, there's not as much compliance for startups as for others, which is true to a certain degree. But the only exemptions that really exist for startups in this ecosystem relate to providing a detailed notice when seeking consent, or ensuring that, startups don't necessarily need to ensure that the accuracy and completeness of the data that they are processing exists. And they also are not obliged to erase data when the retention period is over. And the last exemption that is given to them is the fact that they don't have to disclose exact details of the information they are processing. But other aspects of the Act, including the fact that consent has to be taken before processing personal data, the fact that they have to put in place appropriate security safeguards, the fact that they have to have a robust grievance redressal mechanism, they have to address rights of other data principals, including in relation to when someone requests for a right to withdrawal of consent. All of those things they have to abide by. Additionally, whether it comes to age gating or verifiable parental consent requirements, even those will continue to apply to startups. So it's not a blanket exemption. That is one thing they have to be mindful of. The other thing is that yes, exemptions exist only to registered startups, but even otherwise, if you want to do business in the ecosystem, you want to attract investments, you do want to demonstrate as much good practice and compliance as possible. So those are generally two things that they will need to consider with this law coming in.
Got it. And I'll just turn now to Ashok. So, of course, once people say a company is a startup, it is quite a trite observation. But we do know that it's not like India is bereft of data privacy even today. So, for example, in the fintech sector, the RBI is the de facto data protection regulator. RBI looks at all the sensitive data, especially the financial data. And also in the healthcare sector, any health tech company will have to be required to be very careful about the data it handles, especially if it works with hospitals. And then, of course, there are your B2B SaaS companies which work in the US, European markets, where they immediately require compliance of those countries. So, how do you see it from your perspective? Startups, how do they approach compliance compared to more mature businesses? And do you think that there needs to be a more behavioral change, perhaps, as this law is coming in for startups outside these regulated sectors?
Yeah, I mean, I think one of the things that at least like one since you brought up healthcare and financial services specifically, both of these deal with a lot of sensitive data, which is beyond just taking consent, right? So you are dealing with health records. At some level, I do think there's a responsibility that companies have towards treating that data correctly, be it encryption, be it the way you store, be it the way you process and manage. So while there are some exemptions for startups, but the moment you deal with extremely sensitive data, I think, at least personally, I feel like it is it gets into that ethical issue of whether you're treating these kind of data right. I mean, if you're a e-commerce website which is like which has a shopping cart, I mean, you don't have that much sensitive data versus a guy who's doing patient records. I'm sorry, I mean, I don't think there should be an exemption, to be honest, even if they are given an exemption. Having said that, if I were to look at startups, they obviously, because we do have a DPDP compliance stack today, which is about 8 products that IDfy has built called Privy. We see a lot more seriousness from larger orgs, be it even startups who are larger than the ones who are smaller, right? So we do see that banks, etc., are a little more serious, obviously, because RBI is asking those questions. The regulator, if you're a regulated sector, unfortunately, regardless of whether DPDP specifically gives you exemption, the regulator might not. Right, especially how you deal with sensitive data specifically. So I do
Absolutely. In
think,
fact, yeah, you're quite right. In fact, that is one of those specific carve-outs that they have where sectoral
yes,
regulators can impose more burden. In fact, this is one of the problems that the government is facing, that while there may be an exemption for startups and who knows, maybe for MSMEs also, but how
yeah,
to carve out the provisos to those exemptions.
yeah,
And that's where it will get very interesting because, uh,
yeah,
in the context of Income Tax Act, for instance, everybody
correct,
reads the provisos more than the bare act. So
yeah,
indeed, this is one area to navigate where the law should be such that less reliance on contractual obligations and more
correct,
reliance on black and white law, so that less friction is spent on negotiating uh, additional protection where the law is extremely permissive. So yeah, so that will be interesting to watch. Now, Abhinav, coming to you. Now, you wear two hats, right? You are both CFO and general partner at Gaja Capital. So in a way, that's twice the work because CFO is also in charge of compliance generally, right? So you cannot just invest and say, okay, forget about it, somebody else's problem. So from your perspective, what feedback are you hearing from your portfolio companies regarding issues like onboarding obligations, consent, grievance redressal? So do you get feedback, and where do you see them doing the gap assessment currently for the incoming law?
I see, frankly speaking, I mean, most of our companies at least are praying that the rules that come are far more lenient than the ones that are expected to come out. People have started building the mechanisms like onboarding obligations, but right now the way they are expected to be, or in the draft regulations the way they are so onerous that I'm not sure how will India's SME sector, MSME sector, and all these people will even eventually kind of implement those. Consent mechanisms are becoming far more rigid. Grievance redressal system needs to be managed, and some of the businesses in India that were getting created out of, let's say, a WeWork 10 by 10 office. I'm not sure how much of them will be possible to kind of create after this law becomes this act becomes a law, and how will they kind of implement that? So there are serious concerns about this in the companies, although the companies which are of reasonable scale have started moving towards it. The other challenge that they're facing is the sophistication of the customer itself in India. Indian customer is not as sophisticated as the European customer is. I think half of them don't even understand what is the value of their own privacy and what is the value of their own data beyond a point. They are only looking for services. They're looking for discounts on certain apps, and they are happy to kind of give out their personal data just for that. So I'm not sure, how much of those will be, implemented in the various sectors, especially where there are customers in lakhs and crores for these kind of companies.
No, that'll be very interesting. In fact, you mentioned lakhs and crores. So, question to you, Ashish. Now, other jurisdictions have actually tried to create gating in terms of turnover test, employees test, to try to make sure that not everybody comes under the garb of a startup, which of course, as you know, is anyway a defined term in India. You have to be a registered startup. So the exemption, if any, will come for only those startups which are registered with the government. But even there, for example, California approaches it from the perspective of the number of employees and turnover, number of users. Do you think something like that would help your portfolio companies and the ecosystem comply better? And what would be your suggestions on that?
So if I don't think there is any other way out if we want this legislation to work in a balanced fashion. When I think the first fact is that when we have regulation, it is a step in the right direction because it shows that the sector is not only evolving, it also shows that things are formalizing. And that is the reason why the parliament and the legislature is taking notice of that. Here, the fact that is actually today required is a systematic breakdown between what nature of leaks and what type of entities are committing and what factors are leading to those leaks. The triangulation between three should lead to the eventual penalties. And there have been cases like it has been the case between Shreya and you can add and clarify, but things like civil procedure code, etc., have a lot more in rules. That's the case with indirect taxes in India as well. So the lay of the land is that there is a clear precedence that enough laws in India operate very, very structurally between the law itself and the rules implemented by a board. There is a provision that there is going to be a board under this act as well. So I'm definitely expecting that when that gets formed, all of these things will come into play. And if they end up missing it, I think it's a mini catastrophe of sorts. I'm qualifying, I don't know why am I using the word mini, it's a catastrophe, it's a lost opportunity. So we definitely need to do that. And the other piece is that we shouldn't be waiting for the board to make a few decisions because the cloud of uncertainty is actually worse than implementing something which is perceived to be harsh and then eventually, making concessions for it. So that has to be removed by way of enabling rules, which will end up being the goalpost on the back of which everybody, including the board, will act. Otherwise, we are leaving too much in to test the time, and a few individuals will start taking calls on that. It will not augur well for the ecosystem, and the losers will be the customers because it is at the end of the day innovation which will suffer, the reach and inclusion that will suffer on the back of it. Everybody will take the most conservative view that is possible.
Yeah. No, that's actually very well put. In fact, from a disputes perspective, uh, there are generally two views possible. One is that a robust data protection board will reduce the chances of random courts, random judges taking a view on a law, right? In fact, we are seeing the same problem in our media regulation currently, right? People file cases in district courts, high courts across the country. A different single judge will have a different view on a particular TV show, and some will be liberal, some will be conservative. So, one advantage of tribunals and boards is that within a short period of time, the members of that board will get fairly specialized. They will start to see patterns, they will start to see issues, and as you suggested, they will start to get pragmatic, right? They will understand who are the troublemakers and who are people who are genuinely, sophisticated people who have actually lost something. So, in that sense, there's one advantage. Of course, one thing which kind of troubles me, maybe it shouldn't, is that the government is very keen to make the board online, right? So in that sense, the framework will be different from the Consumer Protection Act framework, where there are consumer forums, district forum, state forum, and you go to those forums and file your complaint. Now, what we have seen in practice as lawyers is that if you have a physical filing and you have a physical appearance requirement, that in itself deters the frivolous complaints because it reduces the workload of the court because you have to think through, okay, fine, there's a certain cost, right? There's a certain initial cost to filing the complaint, unless of
There's
course
some friction.
exactly. So it better be worth it. So if your refrigerator isn't working, it should actually not be working. You shouldn't just be a person who wants to enjoy the air conditioning in a consumer forum. So making it online, the kind of scary thing, and it's an abyss for India, of course, because we've not seen online dispute resolution. So it's almost an experiment. Making it online means that I can just uh, read a newspaper article and then type out any report, and effectively the DPB and its employees will have to go through and vet so many complaints, right? You'll have multiple complaints, they'll all have to be vetted. We also have to factor out somehow how in the future you can have US style class actions on data leaks, because again, class actions, while they're very scary to the reader, they actually help the judicial system, because at least a particular class, for example, if you have a data leak, you will have a certain definable class of people who have suffered. So you will actually have just one or two lawyers representing that class with very similar complaints, as opposed to that entire class, maybe thousands of complaints being filed individually and people trying to tag them as they do. So interestingly, it is an experiment not just in data privacy. This will be an experiment also in dispute resolution whenever it is implemented. So just on that, Ashok, now coming to the deal part of things, right? Because most of the people in our audience are people who are either investors or raising capital. So, what do you think would be your key data-related challenges that, in terms of giving potential investors access to audit information, data rooms? Like we are all used to non-disclosure agreements, right? That has been the historical trend. But now you'll increasingly see what are called data processing agreements, right? So, uh, what do you think would be the approach going forward in terms of handling of personal data? Because as you know, lawyers, accountants, bankers, a lot of people process this data. So any thoughts on that part of it, the deal part of data flow?
I mean, I don't know, at least in the investors that we've had, including Blume here, Ashish, I don't think we've ever shared personally identifiable information. It's largely aggregated and aggregated at an account level. But PII data, at least we have not, we've never shared and never been asked. And I would, and this is, I have like what, about seven investors that have invested in IDfy. I don't think, at least we've not seen that. I think one of the things, at least, especially PII data specifically, I do believe that inside an org, even as regulated as banks, we have seen that data replication, and putting it in a database where, or in logs, we see that quite often in a lot of the banks. Again, like the way you treat PII data and sensitive data, India is not on the top of that list. Let's put it that way. So you might see things in a log somewhere, and so unless you have a great data discovery, data asset sort of inventorization or data lineage system to kind of figure out where your data is, it's going to be very difficult to pull off compliance, specifically compliance to breach, because this data might not have a problem until there's a breach that happens. When a breach happens, now within 72 hours, you need to report to the DPB with remediation. Within 6 hours, report to the principal, data principal, and you'll actually have to do 4 reportings, right? One is the principal, the other one is the DPB, the third is certain, and the fourth is your sectoral regulator. So, and all that within 72 hours with remediation. Like, it's going to be a pain unless you start to plan properly. Right. And I think at least from one side is, do they ask us? The other one is just get the house in order by doing a proper data discovery exercise.
No,
But there
actually,
are obviously
you
tools
actually,
available for all that.
yeah, you hit upon a very important part, the reporting part. When we talk to US councils, they always advise, of course, they have very robust agencies. So whenever there is a data leak, as opposed to like a negligent breach, which they feel is some hacker has stolen data or something like that, they say go to the FBI, forget about compliances, because if in the first 24 hours the FBI is not able to find, and you wait and you do all your filings, then interestingly, you will find that they will actually not be able, the trail will go cold, right? So this was in the context of SEC. Like even in India, a listed company would also have to do a reporting to SEBI. So SEBI will also be interested to know what's happened. So yeah, so I think one other thing we'll have to really ramp up in India is our police forces, the cells which are there in terms of cyber cells. They've been around for a while, but we need to give them better budgets, because often general counsels, compliance officers should try to find the perpetrator also, which is also a very important part of the investigation. But Shreya, just now, Ashok mentioned a very important part of this, which is anonymizing data in transactions.
Yeah.
So that is, of course, critical. And it is very good to know that, investors in Ashok's company have been respectful of that and not, try to do too much of a deep dive. But what can startups and investors do generally to put in place clear guardrails, whether they are contractual, technical, procedural, without, really breaching the DPDP, but also helping the investors in getting as much information as possible, because it is understandable. We've seen globally sometimes, an investor's concern is it real data? And the most common issue is consumer data. We saw a scandal 2 or 3 years back in the US where a company was, inflating its user database, and then, obviously in the anonymization process, you can actually say that I have 1 million users, whereas you may have 10,000. So what do you think are the safeguards that can be put in contractually to ensure compliance, but still maintaining some kind of strength to early stage diligence?
Yeah, so I mean, there are 2, 3 prongs to this really that will have to be dealt with in parallel. The first, of course, being what Ashok mentioned, that as far as possible, de-identification, anonymization is going to become the norm. Wherever there are concerns about the veracity of the information, there will have to be strong representations and indemnities that the investor will need to seek out. Additionally, one other, one other instance that we could see playing out could be that an increase in the number of vendor due diligences. So where the company counsel gets into the data room and analyzes, dissects, and creates the diligence report, which the investor can then rely on. So, I mean, that's as far as data sharing is concerned. And of course, to the limited extent any personal information is required to be shared, we'll have to ensure that it is done under either one of the legitimate uses, or we'll have to ensure that consents appropriately are taken, whether on a standalone basis or otherwise, to make sure there is no breach or unintended violation of the law. One other aspect to consider would be that aside from just the sharing of information, it's going to be important to maintain. I mean, the investors are going to look out and create more comprehensive diligence requirements around data protection now, because the penalties are very, very significant. So aside from just the sharing as part of the diligence requirement, one will have to ensure that the compliances that they have in place should satisfy the investor. So whether it relates to, even if you're a startup, I mean, sometimes investors also look for best practices. So whether it involves having appropriate consent mechanisms, whether it involves the hygiene of how you maintain and secure the personal data that you have, or whether it involves breach response protocols, all of that will have to be properly ensured and aligned with the investor expectation. And this is an exercise which will become increasingly important. And one more point, one of the panelists brought up earlier was about the board not having made any decisions yet. So a significant, I mean, we will definitely see decisional practice emerge over the course of 4 to 5 years. It's not going to be a one-time, I mean, it's not going to be a one decision, rules all outcomes situation. And when that happens, we will have more clarity in these dealings. Particularly, the law does, in the context of mergers and acquisitions, particularly, the law does understand that data sharing needs to take place. So they have created a carve out for court approved mergers, scheme of arrangements, amalgamations, for which personal data can be shared without having to go through the trouble of ensuring consent, anonymization, etc., because there it's genuine. Whether the decisional practice extends that to other kind of investment transactions remains to be seen. And until then, it will definitely be important for all stakeholders to ensure limited access, as an investor, limited access to personal information to the maximum extent possible avoided, because it also comes with a liability. And as far as the target enterprises are concerned, or startups, MSMEs, investee companies, they will also need to limit access as far as possible, because you don't really know how that data is going to be processed going forward. So aside from just having a data processing agreement in place, practically ensuring that you are limiting access is going to be very, very crucial.
No, no, that is interesting. In fact, I personally am of the view that the court merger will not work for investors who are taking
Yeah.
minority stake. In fact, it seems as if the government has only picked up on that one kind of corporate transaction where, in most cases, the transferor will dissolve. So, in a way, the data, it's almost like they are just saying that, of course, the data will no longer be held by a legal entity anymore once the
Yeah.
court approves the merger. So, okay, we'll permit it's hardly a permission, I feel. But I think what could work here is the business purpose test, where they say that if there's a specific, explicit, and legitimate purpose for the data sharing,
Yeah.
so
So
maybe
to,
we'll have to write that in also in a lot of
yes.
term sheets to make sure that, uh, whoever
Yeah.
reads the term sheet later on or a NDA gets the feeling that there is a DPDP
And
compliance.
yeah, and one more thing just to be mindful of, that under the EU GDPR regime, there is something called legitimate interest, which is not a defined term. So that literally and practically in that jurisdiction translates to legitimate business purposes, such as this, for which personal data can be processed. In the Indian context, a similar carve out does not exist.
Interesting, interesting. So, just uh, coming back to Abhinav for a second. So, Abhinav, now as an AIF, you would be also harvesting a lot of data. some of it personal, most of it not. Even at your diligence stage, when you're doing your initial diligence. Now, one thing that I have personally found to be an easy solution is to get vendor diligence done. In that scenario, you have the law firm of the target doing the diligence and effectively processing the data. So the data fiduciary is the target, the data processing. If you have to get into any sensitive data for whatever reason, that would be an easy way to get an external law firm or an external accounting firm engaged by the target to do that kind of data. But in cases where you cannot do that, now, it has always been the perennial issue where investees say that, hey, in the non-disclosure agreement, give the data back to me. That is always a question which is negotiated. So, what processes have you put in place where you tell them that, look, I'll purge the data after maybe a year, and I will not be giving it back. In fact, I will hopefully not retain it, or are you still implementing data retention? Any problems with purging data after a year or two, especially in cases where deals don't go through?
No, see, in the digital world, it's very difficult to purge or delete any data. I don't know where all that data has got stored in our backup mechanisms, on tape drives, whatever places and all that. For me to confirm absolutely with a hand on heart to somebody that I've completely deleted a data in this online world, I'm not sure if I can do so completely. So that is going to be challenge. Having said that, it is very right that, as Ashok mentioned, that for a fund house like us, the most of the data that we would have collected would not be personal in nature. It would have been related to the company. It would have been related to their financial numbers, aggregate level. So it is not something that is very personal in that sense. And hopefully it will kind of find that exemptions that are there under the Act that we kind of keep for ourselves. But almost impossible to kind of delete every trace of a data that is there. I mean, if I'm sure if I ask, some of my oldest deals data to be pulled out by my IT manager, I think in a couple of days he will be able to give me the data files that come into the system at one point of time. So that's not going to be something that's going to be practical given the way the data flows these days. I think we will need to come up with more mechanisms which kind of protect the data. I don't think so. Any of the firms are in violation of using the data other than for the purpose of what it was being called for. And I don't think so that data also gets used in the future. In most firms, once the deal is kind of being passed upon or not being looked at right now. So that's something that gets stored in the backup systems, but really something that nobody really uses them unless a similar sector deal arises. But that data also becomes very stale, very fast, not in live situation. So that's the difference in that sense.
Yeah. No, actually, that's a very good point. In fact, maybe instead of purging, anonymizing would be better, because your analysts will also want to know that data, to analyze, and it might be a good practice once the law comes in to, anonymize it, keep it so that you still learn from every diligence, especially on that particular sector, and how that data set compares to other data sets that you may see. So yeah, so that is true. But I do agree with you. It will be mind-boggling to remove data. Like, for example, even from a law firm perspective, we have a very large and robust real estate practice. And real estate is one of the areas where you have to, put thumb impressions, you have photographs, and even in a corporate lease, for example, it'll invariably be an employee who signs the lease on behalf of the company. And their personal data is all there. It's scanned, and we keep it, I don't know, practically indefinitely on our systems. So indeed, there will be a lot of significant issues, especially for data processors, because even where the fiduciary purges it, there'll be so many different touch points where the data will still be lying about. So I have actually a question for both Ashok and Abhinav. Now, when it comes to maybe Ashok, you can go first on this. What do you think generally startups should do to improve behavior? Because one way of looking at your laws such as anti-bribery, anti-corruption, your laws such as prevention of sexual harassment, competition law, is that these are not just compliances, this also requires a behavioral change because you have to, do trainings, for example, of employees to make sure that, sufficient controls are in place so that incidents do not happen. Because it is practically impossible to do a full compliance of POSH, for example. How can you do it, right? Other than to set up an ICC and all, right? You can only do paper compliance. So, what do you think should happen to improve overall behavior for the ecosystem for data protection?
I'll break this down into 3 or 4 different areas, right? And actually we are going through implementation for our customers on DPDP, so we kind of know exactly what we are doing there. So there are about 4 or 5 streams, and I'll break that into people, process, technology as three broad themes that you can go into, right? From a people perspective, obviously there's like training before people. What you want to do is get the technology to hive out sections which people have access to. For example, do you have good access control mechanisms, role based, so that only those people who really need to see PII data can see it? That kind of removes probably about 70% of your team who doesn't have to see that data, right? That controls how much you need to train, how much training that one specialist team needs versus another. Second is, even from a technology controls perspective, you can make sure that people cannot take photos of the screenshots, things like that. Those are all possible today. There are DLP mechanisms that you can run on devices so that device can't download. You can't even send emails with PII data flowing out of your premise. By the way, we have all of that tech in IDfy, which allows you to stop that. So when Abhinav was saying, can I figure out in my archives whether I have PI data? We can. The technology exists for it. It's not that hard. It's relatively simple provided there's intent, right? That is step number 1. Second is from a training perspective, as a people perspective, there's training as well as see, think about it as breach as 2 problems. One is internal employees and third-party providers. Both the fiduciary is responsible under the DPDP Act, unlike the GDPR world where the third-party provider can be fined directly. Therefore, in the GDPR world, you don't have to worry about the third party as much. Now, think about what that means here in the Indian context is there are third parties who are small little mom and pop shops which are maybe printing a birthday greeting as a bank for your premium customers. That guy gets an Excel with all the names and details, and he prints these greetings. Now, you need to make sure that he deletes it. And people think like passing on unlimited liability will solve that problem. It won't, because that mom and pop shop has a net worth of maybe 2 crores. So your 250 crore fine is not going to solve by unlimited liability. So what is your controls in place in terms of process controls as well as technology controls for third-party management, apart from obviously audit and training of them as well? So it's not just employee training that you need to worry about, but also third-party as well as controls that you have for those third parties. The final thing is about making sure I think you'll need to get more control on the employees that you have to make sure that they have not committed this kind of crime in the past, right? Like, so how much audit are you doing of your employees itself to make sure that they have not done some breach in the past and things like that? I don't know if we as Indian organizations, we are very serious about data leaks as a serious problem, right? We think, oh, agar leak ho gaya, tab we'll put the controls at that point, right? But you need to get deeper about it. You need to kind of, and we are going through one where we have swim lanes for people process technology that we are running programs on. We are not a consultant, but I'm just saying that we are only the technology provider, but that particular entity is going through a whole exercise, which is almost like a 18-month exercise to get fully DPDP compliant. It is not an easy process. It is going to take time because it's not just about technology, like I said.
Absolutely. In fact, the vast majority of clients, and understandably, get stuck like a deer in the car headlights when a ransom attack happens, for example, right? So they are always the first 24, 48, 72 hours are just running from pillar to post. Should I pay the ransom? Should I not pay the ransom? And the vast majority do pay the ransom because the reputational risk involved in a data breach is so significant And often, the way they go to bed at night is to say that at least the hacker helped expose one of the chinks in their data protection architecture. And we should also explore, say, bounty programs for these things, right? Like, as we know, a lot of the big tech companies in the US do that. So, in that sense, I think definitely a lot more maturity will be needed in compliance. And you're bang on that the cybersecurity framework and spending money on that will happen earlier rather than later, and which was frankly something not a priority at all for a lot of tech companies. So in that sense, Shreya, I have two questions for you on this, right? Because we keep talking about the money to be spent, but you do know that startups, especially at an early stage, need to burn cash, on more exciting things in their mind, in some cases customer acquisition, in some cases getting their website ready, ensuring that they acquire the best talent, for example. So the government is quite happy. They are patting themselves on the back, saying that they've created a layered penalty structure, right, where they are trying to ensure that it is only habitual offenders or deliberate offenders who get the maximum penalty, but otherwise it is layered. So, what are your views on that? And secondly, what SOP should be followed uh, by an investor? So, if an investor was to find out that there's a violation by a portfolio, so what, in fact, that one I'll probably ask Abhinav because you would have seen many more legal violations. But what do you think, Shreya, is about the penalty structure? What do you feel about the penalty structure? Is it satisfactory or do you think there's gaps?
Okay, so there are two things I'd like to talk about here: the penalty and what comes before the penalty. First, I will deal with what comes before the penalty. See, whenever there is a reported violation, it will trigger an inquiry. So, especially if there is a breach or even a small violation which could have implications on personal data or adverse implications which have been escalated to the data protection board, they will likely launch an inquiry. What that entails is that they can come and raid offices. They can take the help of law enforcement agencies like the police. They have search and seizure powers. So that is going to, of course, create some level of disruptions in terms of how business is being conducted. But having said that, the government has taken a lot of stakeholder feedback into consideration that, if our equipment, and nowadays everything is online and digital, is confiscated, we can't really operate. So there, the government has indicated that, okay, while all of this is going on, no equipment which is important for the day-to-day operations to be carried out can be seized. So now, in this situation, companies generally have to conduct trainings to, across all verticals and levels of employees, including security guards, in terms of how to handle these situations, how to cooperate, where to draw the line as well. So that is one aspect of a data breach or a violation, which probably we will talk a lot more about once the board comes into effect. But definitely something that everyone needs to consider, be it a startup, be it an MSME, be it a significant data fiduciary. Aside from that, coming to the penalty itself, um, I think it is not a bad situation, even from the perspective of businesses, that there is a possibility to mitigate um, the penalty, given the fact that even in today's scenario, technology has evolved so quickly. You can have one of the, state of the art infrastructure security in place. You can put in place, tools and protocols across all your organization, and there could still potentially be a breach. So it is not for want of, it's not for want of trying that, you don't have you haven't done enough that a reasonable organization would do, which is commensurate to the kind of data you're protecting or trying to protect. And if you have done all that you could do or whatever meets the test of reasonability, they have kind of allowed you to present that to the authority as part of the inquiry process, and they could be construed as mitigating factors. But having said that, of course, if some breach is extremely massive and there are significantly adverse consequences, we don't know how these mitigating factors will play out. So there is definitely lack of clarity there. Aside from that, if you are found to be a repeat offender, and this, I think, is a bit extreme because the violation could be very minimal. For example, maybe you did not take consent for one purpose, but in one instance, and there could be a second violation for something else. So the minute that happens, the board has the power to recommend to the government that your application should be blocked digitally. And that is quite a severe position to take. I don't anticipate it will be used frequently, and it is probably, in reserve for rare situations. But the fact that it exists, it's a bit worrisome.
Yeah. In fact, something similar happened to credit card issuers a few years ago when the Reserve Bank came out with rules in terms of data localization there. And after a bit of frustration, the Reserve Bank told them to stop onboarding new customers. And we also saw something similar in China when Didi Kuadi was asked to stop onboarding new customers because, of course, that was in China at least, it was very political. But yes, I think this is hopefully will only be reserved for the most egregious violators, the most habitual of all the violators, this kind of strong position where they are not allowed to process future data. But now I have a double-header question for both Abhinav and Ashish. Now, as investors, of course, we all know when you draft a shareholders agreement, when you have the share subscription agreement, you have built-in basis protection in terms of compliances. You seek strong clauses which require the company to be compliant generally as well as specifically. And I'm sure over time, whenever the law comes in, we'll see a DPDP clause or a sub-clause there as well. But from a practical perspective, because you bought it, you own it also, right? So, I mean, agreements can only take you so far. What SOP do you think generally do you follow, right? Even today, I mean, I'm not talking about in a future SOP. If you could just throw some light on the SOP that funds generally follow when there is a violation of law by a portfolio which could create a business continuity risk.
Ashish, why don't you go first?
Sure. So, in terms of the typical SOPs, let me break this down and spend just quick 30 seconds on a normal breach, which is other than a data breach, which is what life is until date. These provisions are not in as much of detail where they will get prescriptive in nature. You are going to put onus on the management and the founder to do the right things in terms of the overall compliance. And when it comes to data protection, sure, it might get a little more detail, like how it gets into a little more detail when you have things around anti-bribery, etc. Some of those things warrant a little more context, which will come with data protection. But when breaches do happen, it's actually more about, firstly, what type of a breach it is. Are you in the midst of a ransomware a kind of a situation versus a situation where there has been a leak versus where a regulatory action has already happened? All three warrant a very different set of action. Uh, and in the scenario where you are in the phase where a breach has happened, I think the actions taken by the team are going to supersede anything that you can put as an investor. I want to be transparent here and clearly say that yes, we can get into devising common playbooks, and where there are experts, we can provide to our common platform best practices. But at the end of the day, so far as founders are made available some of those playbooks, access to the expertise, making sure that they are plugged into relevant networks, It is going to come down to how the founders and their teams are going to work on those areas. So it gets into a lot more collaborative action and rather than a knee-jerk reaction and panic. And if you are in the midst of a regulatory action that has been taken, then I think then the investors have a lot more ability to kind of be the founders' proxy to expand their networks and get them in front of the right people to represent the case. Because at times, uh, the way things are, there is an implicit assumption that when some of these things happen, the companies are going to be on the wrong side. So to get that message across, I think becomes a collaborative effort where investors can lead. Happy to go into detail, but since you've asked to both of us, I'll just also switch over to Abhinav so that he can add.
No, thanks, Ashish. That was very useful. So basically, the interface with the potential portfolio companies is in two phases. One is pre-investment and post-investment. I think pre-investment is about the due diligence and what do you find out. And of course, as DPDP will come into play, this will become more or less part of the legal due diligence that you will do on the company. And in most cases, the way I think investors will see it is that is the company completely disregarding the rule of the land, or is the company right now in process of implementation, or at least has the inclination to implement this? This is something that at least we saw when ESG and similar practices became fairly common in India in the 2013 to 2015 era, where companies were required to kind of implement some of their ESG guidelines, POSH Act, stuff like that. And I think it will have a similar roll down when it comes to pre-investment transaction. Post-investment transactions, of course, we are the owners of the business. We need to protect it as much as the promoter has to, and we need to understand did the fault lie as a genuine error in terms of we missed something there, or was it deliberate? And of course, deliberate has a set of actions that you take then. And of course, as a genuine one, all you want to do is protect yourself as a management in the company, because in most cases, your own director will be on the board of the company. You need to kind of create protection layers around it. You need to provide the best advice to the company, get them to the best lawyers, best legal firms that can help them, and try and protect them from the potentials and minimize the damage that can happen to the business because of such an incident. So those are the two different ways you will typically go about these things. I see this has become flowing into the legal DD channels going forward, and then flowing from there, certain conditions subsequent being imposed on the company to kind of implement as we move forward.
Fantastic. So we have about 8 minutes left. So what I'll do is there are two questions which are there. So I'll just ask Shreya and Ashok in turn. So Shreya, one question is very specific. How regulated entities align with the CSCRF, SEBI CSCRF with DPDP? So how do we align? Do they follow both or one?
Okay, so they should follow both. There is no
Yeah, we hope so.
about that. Yeah, to answer your last question first. See, the cyber security and resilience framework that the SEBI has prescribed has a graded approach in terms of compliance and the kind of security measures you have to deploy, depending on the volume of information you have, the number of users, and multiple other kinds of thresholds. The DPDP does not, the DPDP Act does not recognize those thresholds just yet, aside from what will be considered as significant data fiduciaries later on. It has a blanket requirement for every entity to deploy security safeguards and technical measures in the organization to ensure the protection. So while SEBI compliance may have a graded approach, as far as DPDP is concerned, if the sensitivity exists, you have to apply commensurate standards across the board. So in that sense, the regulated entities will have to pick the higher threshold. And here we have to be mindful that SEBI guidelines are fairly prescriptive. They go into a lot more detail. As far as the DPDP Act is concerned, and even the draft rules right now, it is very high level cursory. There are just broad guidelines, base level requirements that have been prescribed. So as I mean, the nature of the information you're collecting, the volume of the information you're collecting are considerations in both places. So you have to keep that in mind when approaching cybersecurity. Aside from that, there is also going to be a robust breach response protocol that you have to adopt in both situations. One, to ensure that there are no significant violations, and secondly, also to ensure that you meet your reporting requirements too. So here, the regulated entities will have to make one additional layer of reporting to the SEBI in this situation.
Yeah.
But yeah, everything else remains similar.
And it goes to your earlier point about decisional practice, because hopefully the DPB through its decisional practice will reassure regulators like SEBI and the RBI, so in a way that they reduce the burden on regulated entities. That's the hope, that they will start to respect that the DPB may not be the sector specific regulator, but is the regulator for general data protection. So in that sense, there is a hope that there will be some relaxation. But we've seen in the case of TDSAT, for example, in the past, and the tussle between TDSAT and the Competition Commission, we've seen that it's not been our experience that sectoral regulators yield too much space to general regulators in any area. Now, Ashok, you mentioned earlier about anonymization and how that is very useful, and you also help a lot of startups in their anonymization and the cybersecurity. Can you share with us some of the biggest mistakes that they often make when they try to DIY this process of anonymization?
I think the biggest problem, like first is, I think at a very high level, data minimization, do not store data you don't need, right? Because anything you store has a potential breach, and a lot of the data we collect, to be honest, almost every journey I've seen in the country is a lot more than what you should be. So data minimization is as a first step. Second step is, like, a lot of times we don't even know where we're collecting these data points from and where we are storing it. For example, if I look at imagine, I mean, you might forget about the startups, like even large companies do this, right? If you remember some of your KYC processes, which are physical, the guy actually tells you to send that data on a WhatsApp. Are you even looking at deleting data from that device, for example, because you don't know where you're collecting that data from and where is it getting stored? Some of these, even though you might have, by definition, WhatsApp has encryption, but inside the device you can anyway download it and keep it, right? So I think the biggest problem is a lot of our fiduciaries just don't know a source. Whereas, so almost like an audit or a gap assessment of how you're collecting data is the first step to figuring out what your potential data leakage points are. So you can anonymize only those things where you know how to anonymize. So there's pseudonymization, anonymization. There's lots of things you can do, but if you don't know your process, then you're anyway kind of broken. I think that's the biggest gap I feel.
No, absolutely. You're quite right. Ironically, regulated entities which automatically have the largest compliance budgets on cybersecurity, data protection, they are the most relaxed about it, right? So, you mentioned WhatsApp. Often, you have a lot of warnings against sharing of OTPs and all. But, often you find brokers, SEBI-registered brokers saying, okay, fine, you share your OTP on WhatsApp and I'll do it. So it's almost like, the company is telling you one thing, but the employees or their agents are telling you another thing. Maybe
I have a very interesting point here. Can I just, but it's very short. So I do eat street side bhel puri. I really love it. So one day I got this bhel puri, and the paper there had somebody's PAN card, which said original seen and verified by the bank's name as well. So, so you can see what is our protocols on sensitive data, if you may, right?
No, and it also reminds me of many years back, one of my partners, he told me that it's always safer to drive yourself in the hills.
Yeah.
Because when you have a commercial taxi driver, because they do it so many times,
Yeah.
they themselves are very blasé about hill driving and the signs which are there. You will be more cautious. So that's very interesting. So we are now at 5 p.m. So if anybody has further questions, please do write into Paromita. She will forward it to all of us for our thoughts, and we can keep this conversation going. The idea, of course, of this session was to give all of you a broad overview as well as experience sharing from a wide variety of panels uh, of how this law will play out, how it is all about behavior as opposed to box ticking compliance. You heard from the investors. Ultimately, it will be your problem, right? They are your investors, but they will say that you, being in charge, you are in the driving seat to make sure all the employees, all the good investments are made. They want you to win, but that day, even Mark Zuckerberg, by the way, does no longer says, move fast and break things. So the culture of compliance is critical, and especially true for any company which is dealing with sensitive data. The RBI, SEBI are onto you. They anyway prefer fit and proper persons. They made that very clear in fintech. So we should all try to push a strong culture of compliance. And with that, thank you very much, Abhinav, Ashish, Shreya, Ashok, for joining us. And thank you, Paramita, for having us here.
Thank you so much.
Thank you. Thank you.
Thank you.
Thank you.